Well, hello and good morning to another daily update on the California Board of Psychology issues. Today I'm going to be talking about my sacrifice, basically sacrificing my career to break the isolation um, of the parents and children in the family courts and to return them back into established professional psychology. And now, to begin with, I just want to say I'm not going to try to argue the case here over the next few days. I've given you all the information. You can decide, and the hearing's public. You can do that, and there'll be a transcript, so that'll all be documented in. And I'll describe that in a little bit. So, in the first couple of updates there, I provided you with the information, my defense, and the motions in the mind going back and forth. And so that's you can figure it out for yourself, toss it into an AI. My defense is basically that it's true. My criticisms are true. That I have a clinical duty to protect because this is abuse pathology. It's a dangerous pathology, child abuse and spousal abuse. So I've got clinical duty to protect. And I've got mandatory, obligated, required obligations under Standard 1.05 to take further action appropriate to the situation when there's ethical violations or when I believe there might be ethical violations by another psychologist. And that would be violations to 2.01, 2.04, 9.01, and 3.04, and all three principles of the Belmont Report regarding experiments on human subjects. So that my actions are actually required by the APA Ethics Code, and that my criticisms are truthful and duty to protect. But because the California Board of Psychology has not accepted my discharge of my duty to protect them, I still carry the duty to protect. I haven't discharged it. So, since the licensing boards, who would be the appropriate institutional authority to receive a discharge of duty to protect relative to their citizens, is instead choosing to uh, basically eliminate me from the family courts in favor of the self proclaimed parental alienation experts and their pseudoscience, that obligation and duty to protect then moves to the next higher order, which is the legislatures who oversee the licensing boards, and then to broader media and things relative to the APA. Why aren't they there? And the role of the AFCC and the role of the custody evaluators. And that might ultimately go into a class action lawsuit or something like that. Psychologist, attorney, I'm not necessarily involved in that. But but I have to anticipate relative to the parents and children in the family courts who are being abused, undiagnosed and untreated child abuse, undiagnosed and untreated spousal abuse, that this has a broader public interest kind of thing, and I'll talk about that in a second. So from here on into the hearing, I anticipate more. I'm going to be talking about just the situation for me personally, and just documenting some associated features into the record here. So let's begin today. Um, so first off, I'm a trauma psychologist. If you look at my background, I come out of right before the family courts. I came out of child abuse and trauma. I was personally treating child abuse. And not only that, let me pull this down for a second, because not only that, I'm not just competent in child abuse and complex trauma, I'm senior staff. I was clinical director, 3 universities, getting occupational therapy and speech and language and psychology services. I just didn't work at the clinic that got CPS referrals. I was in charge of the clinic, and I was training the staff and doing all that. So I'm an expert in child abuse and complex trauma. This is my pathology. And one of the classic, absolutely classic features of abuse pathology is that it isolates its victims from reporting and rescue. You can think of spousal abuse and that husband isolating the wife, or sex abuse and that predator isolating the child. And this is exactly what has occurred in the family courts with the parents and children who are being denied standard healthcare services of a DSM-5 diagnosis and treatment, while this unregulated experiment is being conducted on them regarding a quasi-judicial role for doctors of advising the courts on their custody decisions. Let me say something about that. Courts are totally capable of making the custody decisions. What the information the court needs is which parent's abusing the child, what's causing the child to reject a parent. And it's only child abuse by one parent or the other. It's a child abuse by the targeted parent causing the child to, want to get away from that parent. Or it's a factitious attachment pathology being imposed on the child, disorganized attachment, for the primary and secondary gain of the allied parent. That's a shared persecutory delusion and factitious disorder, child psychological abuse. So that's the only thing that causes that symptom. So one way or the other, it's child abuse. So you can tell over the last 40 years the extent of the misdiagnosed child abuse, because it should have been returned in every single case. But they're not. The forensic custody evaluators aren't diagnosing anything, and they're not competent because they're doing their experiment. And then we have the pseudoscience of parental alienation and the self-proclaimed expert in that, who are diverting people into a discussion about made-up pathology labels rather than applying the DSM-5. The moment we apply the DSM-5, everything is solved. Everything is solved. But they simply refuse to do it. The forensic custody evaluators say, nope, not going to do it. The self-proclaimed PAS experts say, nope, not going to do it. And I'll talk about things. So that's what's happened in the family courts. We have this unregulated experiment on this quasi-judicial role for doctors. And then they developed an experimental assessment procedure they call a forensic custody evaluation. And oh my goodness, those are just awful. I get to read them. I'm a second opinion in the family courts. I know what assessments should look like and be. And oh my goodness, these are just awful. But they never get reviewed by licensing boards because they're granted quasi-judicial immunity. And plus the release information barriers are so substantial. So there's no oversight of this experiment. And there hasn't been for 40 years. No risk-benefit analysis, no special protections for a vulnerable population. And they are withholding clinical diagnostic services and offering only the courts and parents only their forensic custody evaluation approach. This is so bad. Anyway, so, and it's in violation of all three principles of the Belmont Report. And essentially what we have over here is regulatory capture and institutional capture of the APA and the licensing boards. And that's the primary source for that construct is George Stigler. And there's his article on regulatory capture, his primary article. And regulatory capture is defined as the regulatory agency becomes dominated by the industry it is supposed to regulate, prioritizing the interests of the regulated professionals over the public. So the quote from Stigler, as a rule, regulation is acquired by the industry and is not designed and operated primarily for its benefit. That regulation is not directed at the protection of the public, but at the protection of the regulated industry. And then the second feature that's going on over here is called institutional betrayal trauma. And that was described by Jennifer Freud at the University of Oregon. There's her primary article. And the definition of institutional betrayal is when occurs when an institution fails to protect those who depend on it, responds inadequately to reports of harm, or actively enables or perpetuates harm. And here's a quote from Freud on that. which is institutional betrayal occurs when institutions people depend on for safety and well-being fail to protect them or engage in actions that harm them. And institutional betrayal includes acts of omission and commission by the institution that betray the trust of those dependent on the institution. And institutions often respond to reports of wrongdoing in ways that silence victims, protect the institution's reputation, and perpetuate harm. So I want to start this, talk today about documenting, and everybody gets really clear on who I am, because I am not only competent in the relevant domains, I'm expert in the relevant domains. I'm like one of your top tier senior staff experts in the relevant domains of pathology here. And they're trying to get rid of me, get me out of the family courts, because if they sanction me, I'll have to leave the family courts. Cross-examination will say, oh, you've been sanctioned, for, unethical practice. And it's going to support the PAS people. They're going to say, you can't criticize us because if you do, the licensing boards are going to sanction you. And so they're basically getting the licensing boards to validate this pseudoscientific thing that they're coming up, because they can't get the APA, the American Psychiatric Association, totally reviewed it and said, nope, it's not really a thing. So they're trying to do an end run on that by saying it's unethical to criticize us. No, it's not. My criticisms are true, but we'll deal with that at the hearing. But I want to get clear here that I have high-level knowledge of the attachment system, early childhood mental health. That's a subspecialty practice dealing with the attachment system. Plus, I have infant mental health certification. So I know 2 different diagnostic systems, 2 different treatments for attachment. I have 12 years for delusional thought disorders of being trained to 2 of the top experts, the co-authors of the brief psychiatric rating scale, Doctors Lukoff and Ventura. And I was trained to 90% diagnostic reliability with them for assessing delusional thought disorders and all the psychotic symptoms over 12 consecutive years. I went through this training. And then child abuse and complex trauma, again, a clinical director position. I'm senior staff. I have knowledge of IRBs and Belmont report and what's required for those. Because I was an invited consultant. They OPRR called me and said, hey, would you come back to Washington? We need some input on the internet and research ethics. So I went back there. And then I have community clinical psychology. I was trained in that. I have a master's degree in community psychology, which is the regulatory capture and institutional betrayal trauma and what's going on over here. So let me start by saying there's no such thing as parental alienation. That is a fabricated pathology label. It just doesn't exist. There's no pathology unique to the family courts that requires a unique set of new symptoms. That's just logically incoherent. Plus, it's already in the DSM. So if it's already explained, then it can't be a new form of pathology they're discovering. They're just not applying the DSM-5 and then asserting they're discovering something new. It's like going over and saying to ADHD or something, we've discovered a new behavior problem of overactive behavior syndrome. No, it's in the DSM-5. It's like ADHD. Anyway, so the correct professional term for what is being called parental alienation is child psychological abuse. It's child abuse. And so when you use these euphemisms, you're covering up the fact that it's child abuse. You're covering it up from the court's understanding. You're covering it up from the targeted parent and their attorney so that they can't argue for a protective response from the court. And you're in diagnosis fault guides treatment. So you're not treating the child abuse, you're treating something else that you think you're discovering. And so, no, we use a DSM-5. It's child psychological abuse. Plus, The correct professional term is a shared or induced persecutory delusion. That's DSM-5 297.1, a delusional disorder. It's in the DSM-5. You don't need to get something new in there. Just apply the DSM-5. The correct professional term is also a factitious disorder imposed on the child for primary and secondary gain to the allied parent. That's a DSM-5 diagnosis of 399.19. And then we have the correct professional term is spousal abuse of the targeted parent by the allied parent using the child as a spousal abuse weapon, DSM-5 995.82. So it's already in the DSM-5, and it's been there for 40 years. In the DSM-4, it was actually there. It was a shared psychotic disorder. That's a shared persecutory delusion. I'll talk about that in future, daily updates. I'll give you the criteria for a shared persecutory delusion from the DSM-4. It matches like a glove. So they just didn't apply the DSM for 40 years. Meanwhile, they're fighting as to whether parental alienation is a real thing. No, it's not. Apply the DSM-5. It's already in there. It's insane. So one of the things about this, look at me, old guy. I'm 70 years old. This March I turned 71. Now, from family history of my father and my two older brothers, I'm anticipating death at around 74 plus or minus 2 years. So let me just say something about that, because old, it's part of life. It's what we do. But I had my father and one older brother both died of strokes and heart attacks. I've already had a stroke. It dropped me to the floor. Half my side was disabled. That's why I walk with a cane, is because I'm a little unsteady in my balance from the previous stroke I've had. And my father and brother have both died from strokes. My other brother died from complications of Parkinson's, and that's on my mom's side. Her grandmother had the Parkinson's. So as I'm looking at my life expectancy or planning ahead kind of stuff, I'm thinking maybe I only have another year or two here, and then I'm going to pass off. And so that's a lot of what I'm doing right now, is giving the parents and your allies and the people that are coming after me all the information that I've generated through 15 years in the family courts. When I got over here, I said, oh my goodness. So I started the push. So I know. So not only all that other expertise that I was talking about, I've got 15 years in the family courts. I know exactly what's going on. Are you kidding me? Every month I do triage in the family court. So I hear your stories, and I've heard them for 15 years. And so I'm competent expert in trauma and child abuse. Okay. So the treatment for abuse pathology is to break the victim's isolation and connect the victim into protective resources. And if that is going to take the sacrifice of my career to get professional help to the victims of undiagnosed child abuse and spousal abuse in the family courts, then that's the price I'll pay for you and your children. And it's not one I want to pay necessarily. I'd like to just ride out the last few years of my life okay. But if that's what it takes to protect the children and parents, well, then sacrifice me. But when you're doing it, I'm going to make sure that it breaks the isolation, because the child abuse must stop. I've watched it for 15 years. I've tried to get the APA to do something. I've tried to get the AFCC to do something. I've tried to get the forensic psychologist. I've tried to get the supposed experts in parental alienation to do something. But it must stop. The spousal abuse must stop. This is the most brutal spousal abuse. Oh my God, these parents are having their children ripped away from them, and they're spending the life. Let me say something about that, because I've taught developmental psychology. I'm a child and family therapist, and I know developmental psychology. And you look at somebody like Erickson on the developmental stages, The developmental stage of adulthood is called generativity. That's either your work or your family. You're being productive and generating into the world as an adult. Work or family. So unemployment is devastating to that sense of self. But so that your mom or your dad, that's who you are with your child, and you've been looking forward to being a parent your entire life. Now you have two children. You want to be mom and dad. You love that child. And that child's been ripped away from you by the court in alignment with your ex narcissistic borderline parent and all their manipulation. And the mental health people just watch it and sometimes, often, facilitate it. The child being ripped away. And you are forced, as a parent, you are forced to watch your beloved child twisted into this angry, fearful, just somebody you don't recognize, not a healthy child, not the child you wanted. This is the most brutal spousal abuse possible. And I've worked child abuse and I've seen abuse pathology. This is awful. And the institutional betrayal must stop. The APA licensing boards need to get in here and make sure that both the parents and children are getting quality services, but also that the court is getting quality mental health information for its decision making. The court's going to have a tremendous impact on these children with its decision of which parent and what the custodies get. And if I got a child rejecting a parent, that's child abuse somewhere in the family, and the court has to figure that out. But it's not getting diagnostic information about the child abuse. It's getting advice on its custody schedule. It doesn't need that. And that's where the risk benefit analysis would have stopped that. If there was an IRB review of this, it would have looked at risk benefit and said, wait a minute, you're not serving the court's interest, you're not serving the parent's interest, and you're not serving the child's interest. You're serving your own interest to conduct a cushy 6 to 9 month assessment when it's possible child abuse. Oh my God, that's awful. But 6 to 9 months, I've seen custody evaluations come in that have taken years. 2 years to conduct a custody evaluation when it's possible child abuse. And by the time you end, that's the child's 2 years older. It's like, oh my God, this is so bad. But there's no regulation. They can do whatever they want, whatever they want. And so we need to break that isolation and get these families back into clinical services because they're being denied that. There's no parent. The parents cannot find or get a diagnostic assessment for child abuse. That's being withheld from them. They have to go out to DBT therapists and see if they can recruit them into the family courts for the borderline spectrum, or the spousal IPV therapist and recruit them into the family courts for the narcissistic spectrum, because all the psychologists in the family courts don't assess for child abuse. It's insane. It's absolutely insane. And I've watched it for 15 years, so this needs to stop. And the experiment on human subjects need to stop. The New York Blue Ribbon Commission that found that forensic custody evaluations are dangerous, harmful to children, lack scientific and legal value, and lead to defective reports, quote unquote, that result in potentially disastrous consequences for parents and children, that without meaningful scrutiny, they can result in potentially that. Now, where do you get the meaningful scrutiny? From other forensic psychologists? No, everybody just fights about that. Hello, clinical psychologist, worked up 15 years. I'm doing the meaningful scrutiny. And that's exactly what the California Board of Psychology wants to remove from the courts. They want me gone. And so then you will get a return to forensic custody evaluations that solve nothing but take tens of thousands of your dollars, but doesn't solve anything. Oftentimes, they actually repeat them 2 years later. They get a second forensic custody evaluation saying, look, your last one didn't solve anything, so let's do it again. And so they don't solve anything. They don't give the court. And you'll get parental alienation syndrome. Actually, it's going to switch, or they were forensic custody evaluators were trying to switch it over to parent-child contact problems, but I kind of cut them off because there's two vectors going. One is the PAS experts, but the other one are the 6 licensing board complaints I filed against the forensic custody evaluators. So no matter what happens to me, California Board of Psychology currently has 2 licensing board complaints against top forensic custody evaluators on standard 2.04, 2.01, 9.01, 3.04. And so they're going to have to figure it out, and those aren't going away. And you can continue to file those. You can get a VITA, run it through your AI, take a look at it yourself, and say that 2.01 violation, boundaries of competence, not competent in attachment, not competent in delusional thought disorders. Add complex trauma and child abuse if you want. Add family systems if you want. But I think the 2 is nice and clean because they're not going to have that. And so it's not going away. And as I was saying, look, 70 years old. And so if I leave the planet, then you guys still have the resources that you need to continue to protect your children or try to get protection of your children. And the moment because if the argument is clearly the New York Blue Ribbon Commission and Dr. Childress. So you have 2 vectors of information, 2 credible reports of Belmont report violations and dangers and harms to the citizens of the state. Okay, so the licensing boards should review forensic custody evaluations, and that's in my settlement counter proposal. That's number 3 of them, just requesting all the VITAs of the forensic custody evaluators in their state, run it through an AI review. They can construct it. They can use my VIS. I posted it and I told them how to construct one. And so you run it through your AI and see if they're competent in attachment and delusional thought disorders and the other stuff if you want. And just to review it, just take a look. Just take a look. Because once you do, you'll find that the mental health people in the family courts are not competent. And it's the state licensing boards who are supposed to be protecting the citizens, not the industry, not the forensic custody evaluators. And so that's a second one going through that they're going to be kind of stuck on. So I've been in the family courts for 15 years, and I have never once conducted an experiment of a forensic custody evaluation on the parents and children because I'm a doctor. I diagnose and treat pathology. I do not experiment on human subjects without an IRB approval. And I have never once, not once, advocated for pseudoscience. You can see that in my first email with Burnett. I said, this is a shared psychotic disorder. I'm not saying it's parental alienation. I joined the parental alienation study group. I said, this is a shared psychotic disorder right off the top. So I've never once advocated for pseudoscience. Standard 2.04 of the APA Ethics Code, Bases for Scientific and Professional Judgments, requires mandatory. Ethical standards are not optional, they're not discretionary. Mandatory requires that our professional judgments be based on, quote, the established scientific and professional knowledge of the discipline. That is the DSM-5, that is attachment, that is child abuse and complex trauma, that's personality disorders and persecutory delusions, and family systems. The APA Ethics Code is not optional. 2.01 is mandatory. That's boundaries of competence. You must know the knowledge. 2.04 is mandatory. You must apply the knowledge. And 1.05 to report and to take further action appropriate to the situation is mandatory. It's not discretionary. So I have required obligations when I believe there might be an ethical violation by another psychologist. Well, I'm pretty certain there is because I'm like expert level in all this stuff, and I'm looking at them saying, not so much. So that's mandatory. And yet when I fulfill that obligation and take further action about criticizing this pseudoscience, The licensing board wants to get me out of the family courts. Okay, so good luck to you. But that's the thing. If I'm removed, it's not going to go to parental alienation because the forensic custody evaluators are in the process of switching it over to a new fabricated pathology called parent-child contact problems. But I kind of did an end run on that. And so now let's get both of those looked at. Resist refuse dynamic is the other one they're kind of tossing into the mix of fabricated pathologies rather than apply the DSM-5. And that's what needs to happen. We need to use the DSM-5 because if we do, the exact moment we start applying the DSM-5 to the pathology in the family courts, the problems in the family courts are solved immediately. Try it. Try it. I dare you. I dare you. Try it and see what happens. Because you know what's going to happen? Your problems are going to be solved immediately. You're going to diagnose a delusional disorder because there's criteria for that. You're going to diagnose a factitious disorder because there's criteria for that. And either one of both those land on child psychological abuse. And both of them are going to be present. It's not like one or the other. It's going to be a shared delusion that's creating the factitious attachment pathology. It's a thing into itself. And you're going to look and you're going to see borderline spectrum on one side. You're going to see narcissistic as the other variant. And it's a dark personalities, dark triad, dark tetrad, and vulnerable dark triad. They're all subclinical. And so try it. But when I offer that for 15 years, I'm saying use the DSM. You know what the mental health people say? No. They just say no. They're not going to apply it. And I get parents, and when parents used to do that in 2017 or 2018, I was pushing parents to go and say, apply, get a checklist. I have this little checklist and ask them to do. The therapists and the forensic custody evaluators would not only say no, they would retaliate. They'd use their positions of authority with the court to retaliate like that parent's uncooperative because you're exposing their ignorance. That's a narcissistic injury. And so I had to stop telling parents to seek the DSM. I'm back to doing that. But for a while, I had to stop telling them because the mental health people, the forensic psychologists, would retaliate against the patient if the patient challenged their competence. It's so bad. And the moment you apply the DSM-5, then I'm going to be totally validated in everything I say. Because it's been misdiagnosed for 40 years. You're going to start diagnosing the child abuse because that's what it is, one way or the other. That's the only thing that produces a symptom. And that's going to be clear then that you didn't diagnose it for 40 years. And the moment you stop the forensic custody evaluations to review those, because you got 2 reports coming in that they're dangerous. And so the moment you say, well, okay, let's take a look and see what's going on with this, and you stop that practice, the whole mental health system in the family courts just falls apart, and you have no mental health services in the family courts because that was the only thing you were giving them was a forensic custody. So it's going to be such a mess. And here I am, the expert in all the pathologies, and they don't care. They're gonna go. Why aren't they working with me to protect the citizens of their state? Now, you think this is in California? No, it's your licensing boards too. It's all 50 states. So if this ever moves into a class action, it's going to be on 50 state licensing board. And the moment one pulls the forensic custody evaluations, that's going to look really bad for the other ones in a class action. And so it's going to be quite something. And so if I'm going to sacrifice my career, we're going to break these families out of their isolation. We're going to get them back to clinical services. We're going to start protecting children, even if it's after I'm dead. But it's going to happen because it needs to happen. This is child abuse. This is spousal abuse, and it needs to stop. So, abuse pathology isolates its victims from reporting and rescue. The treatment for abuse pathology is to break the isolation and connect the victims to protective resources. This is institutional capture, regulatory capture, institutional betrayal trauma. The treatment, look, trauma psychologist, The treatment for institutional betrayal trauma is called institutional courage. It requires the institutions to acknowledge what they did, and so it takes the blame off of the now adult children and off of the parents. You did nothing wrong. That's what we always say going in with a child abuse victim. That's the first thing we say to them is you did nothing wrong. It's not your fault. Bad people did bad things to you. We're going to make it stop. Okay, that's the first thing we say. And that's what the institutions need to say as they outreach, and they need to outreach to the institutional victims of institutional betrayal trauma over the last 40 years and say, our bad. Okay, it wasn't you. It wasn't something about you, the targeted parent. You did the right things. You fought as well you could. You depleted your financial resources. You did everything you could. It's not your fault. You did nothing wrong. Bad people did bad things to you, and we're going to make it stop. And for the now adult children who have come out of this and they're now in their 20s, 30s, 40s even, who are trying to figure things out and who believe it was them. Either they believe that this normal parent who loved them very dearly didn't love them, or they believe that they betrayed them and it's their fault because now they get some insight into that and they go, oh my goodness, I was captured by the pathological parent. Now their guilt is off, and if they don't know their identity and they may be working it out when they're new families, they may have mommy issues or daddy issues from all of this. So we need to get out there to them and help them understand it's not your fault. As now adult children, it was not your fault. You did nothing wrong. The people who should have protected you, the mental health people, didn't. We failed. And so, and even the allied parent, they're damaged. They were damaged by their childhood. And so, yeah, they're kind of fragile and pathological, and they did what they did, but it's not even their fault. It's the fault of the mental health people who should have recognized it and gotten in and made sure everybody's safe, made sure you're safe as the child. We should have done that. We should have made sure that your beloved targeted parent was safe and that we could stop this and maintain the bond, and we didn't do that. And that's called institutional courage, to step up. Trauma psychologists, I know this stuff. Okay, so that's what needs to happen here. So with that, that's going to be my daily talk coming into the upcoming Board of Psychology hearings. Hopefully it doesn't require my sacrifice. So hopefully the board, my case is going to be clear that first that it's true. All my criticisms are true. So they're going to say, I'm going to testify. I'm going to do direct examination of myself, which is an interesting concept. But I'll do direct of myself and I'll lay out my obligations under clinical duty to protect in 1.05, that my criticisms are mandatory, my criticisms are true. And then I'll be subject to cross-examine by the state, and then I'll explain why they're true and why they violate 1.05 and why I'm required, mandatory to do that. And interestingly, we got that opposition to my motion in the mind because I want to establish baseline evidentiary standards. I don't want this pseudoscience and made-up pathology labels used as coming in, because then we get arguing about parental alienation, and that's not the pathology. It doesn't exist. Unicorns don't exist either. I don't want testimony about unicorns. And so I am required, mandatory, to rely on the established scientific and professional knowledge of the discipline. And that's a standard I hold to other people relative to my 1.05 standards for taking further action is the APA Ethics Code. So that's my defense, mandatory and truthfulness. Now, the opposition from the state is arguing, and you can upload it. That's provided. You can upload it. The aides for the state legislators can upload it. Other attorney, everybody can upload it and see what they're arguing. That they are arguing that the APA ethics code is not relevant, that the DSM-5 is not relevant when that's the basis for 2.04, and they're arguing that the truth is not relevant. And I'm not a lawyer, but when I put that through my AI, the AI just goes, not so much. That's a due process thing. The truth is always a defense. So if they get their motion, I said, well, it sounds like we might have grounds for appeal. And the AI said, yeah, First Amendment, free speech, if it's true, it's true. But then there's all sorts of, I am allowed to present the defense of that I'm required by the AP Ethics Code, and what I'm saying is true. And if you take that away, that's a due process violation. So then I can appeal it, and that's going to extend everything out for 6 to 18 months. And so we might have even further, and we can bring in legislators, and we can bring in class action lawyers and stuff, and looking at what's going on. You're the ones. It's your kids. It's your life. Okay, I've done my job, which is to put myself on the line for you, and the willingness to sacrifice for you, and to spend 15 years here doing this and working with you. I'll talk about this maybe more in future months. But when I first arrived here 15 years ago, and you can look at my vita, I never wanted to work in the family courts. I have early childhood mental health. That's not relevant in the family courts other than the attachment pathology. I want to be working with the wee ones, the little 5-year-olds and stuff. And, autism spectrum and attachment pathology going on 0 to 5, parenting issues and all that kind of stuff. I've also got ADHD. I'd like to get back to that. But when I got here and saw what's going on, because I know the pathology, I know attachment delusions, and I see all this, I go, I can't leave you. I can't leave you and your children, because if I do, there's nobody that's ever going to come. And so I stayed with you for 15 years, and I tried to do what I could. I was hoping we could get systems change just from my efforts. But obviously, I went petition to the APA, 19,000 parents. Totally ignored it. The APA totally ignored it. And we can't get into the licensing boards because they give quasi-judicial immunity. So there's no reporting to the licensing boards. But then what I've done is the forensic custody evaluators, because they're the real ones. The PAS experts are a sideshow. But the forensic custody evaluators is building my stature in the family courts and getting in a position where I can review their reports, because I'm the only one. They don't go in the licensing board. So I got into the legal system on the evidentiary track. And so they allow evidentiary challenge of the reports. So I get to read their reports and provide a second opinion. So that was my way of offering protection to you parents and children from their defective reports that are going to result in disastrous consequences. So now if the California Board of Psychology removes me from the family courts, you're not going to get any meaningful scrutiny. And guess what? You're going to have, not potentially, you're going to have actual disastrous consequences from parents and children. But it seems like the licensing board doesn't really care about that. It doesn't really care about the harm being done to its citizens. It cares about the reputational harm to the self-proclaimed PAS experts after 40 years of failure. We've had PAS for 40 years. This is not something new. Look at me, old guy. Bill Burnett, Dr. Burnett, he graduated medical school in 1968. I graduated high school in 1972. 4 years after he graduated medical school, I graduated high school. So he's the same as me. He's going to leave. Amy Baker's going to leave. And all these, Lorandos is going to leave. All these 40-year experts in this made-up pathology label are all going to leave as the generation leaves. Who's going to follow them? Do you think the people that are going to follow are going to be, let's do parental alienation from the 1980s with Gardner? Or do you think they're going to apply the attachment knowledge of BoP and Tronic and Lyons Ruth? Do you think they're going to apply family systems of Mnuchin and Bowen and Haley and complex trauma of Vanderkook and personality disorders of Linehan and Milan? Who do you think they're going to apply? The established knowledge, or do you think they're going to go back? The next generation coming through is going to apply the established knowledge. Okay, and so that we're in a transitional period here, and the moment it transitions, everything I say is true, and the things are inverted, institutional capture. So with that, I'm going to head off to the tasks of my day, and we will talk with you tomorrow. Take care. Bye-bye.